Good afternoon. Welcome to Garfunkel Wild's webinar on New York's medical marijuana program, what all healthcare providers should know. Today we'll present on the federal law policy regarding medical marijuana, how the New York program works, recent developments in the program, how to avoid pitfalls, and questions and answers. You should see a questions field on your screen. Enter your questions in this field, and if we have time at the end, we'll get to the questions. A little bit about Garfunkel Wild. Garfunkel Wild was founded over 30 years ago with a single purpose in mind, to attend to the specific business and legal needs of our clients in the healthcare industry. We represent one of the largest and most diverse groups of healthcare clients in the tri-state area. We have nearly 100 attorneys in New York, New Jersey, and Connecticut. What's unique about our firm is that every single attorney's practice touches on healthcare. We're consistently ranked Tier 1 in healthcare by Chambers, and our newest office is in Albany, New York. My name is Sandy Jensen. I'm a partner here in the Albany office of Garfunkel Wild. Prior to joining Garfunkel Wild in 2015, I was an attorney within the Bureau of House Counsel, Division of Legal Affairs, for the New York State Department of Health for nearly 14 years and served as acting director of the Bureau. Also presenting today is Jim Deering. Jim is also a partner in the Albany office. Jim served as general counsel of New York State Department of Health and served as the department's deputy general counsel and director of the Bureau of House Counsel earlier in his career. As general counsel, he was the chief legal advisor to the Commissioner of Health and oversaw approximately 125 attorneys and staff. So today we'll begin with a discussion of the federal law concerning medical or marijuana. Under the Federal Controlled Substances Act, marijuana continues to be listed as a Schedule I drug, and its possession and distribution is legal under federal law. Despite this, more than 29 states, including New York, and the District of Columbia and Puerto Rico have enacted medical marijuana programs. So under federal law, there is no exception in the Controlled Substances Act for marijuana use for medical purposes, so it's still illegal. Now, under the previous administration, the Department of Justice issued a series of memos regarding enforcement of federal law with respect to marijuana. And the memos basically said that in those states that have legalized marijuana and have strict laws regulating and enforcing this conduct, the feds would leave it up to the states to enforce these laws. And instead, they would focus their efforts on a list of enforcement priorities that they identified in the memos. And that included preventing the sale of marijuana to minors, preventing the revenue from the sale of marijuana going to criminal enterprises, gangs, and cartels, and preventing diversion of marijuana from states where it was legal under state law to states where it was not legal. So they would basically focus on the criminal aspects of it and would leave it up to the states to focus on enforcing their own laws. In 2014, the Rohrabacher-Farr legislation was first passed, and that prohibited the Justice Department from using its funds to interfere with state medical marijuana laws. This legislation was included in an annual funding bill and has to be renewed every year. And this was recently renewed by President Trump until September 30th, 2017. So we'll continue to monitor the federal position. Recently, Press Secretary Spicer stated that the President sees a big difference between the use of marijuana for medical purposes and that used for recreational purposes. But again, we continuously monitor any guidance or statements out there to see what position the administration will take.
So Sandy's provided an overview of the federal law. Now we'll turn to providing an overview of New York state law, and in particular, New York's medical marijuana program. So Governor Andrew Cuomo signed the Compassionate Care Act into law on July 7, 2014, and that established New York's medical marijuana program. And the Compassionate Care Act essentially required the New York State Department of Health to have the medical marijuana program operational within 18 months. And DOH accomplished this with the dispensing of medical marijuana in New York State beginning in January 2016. And I've heard it said that this is the fastest implementation of a medical marijuana program after the implementation of or passage of legislation in any state in the U.S. So how does New York's medical marijuana program work, and who are the main participants in the program? In addition to practitioners and patients, the program obviously involves the New York State Department of Health, as well as certified caregivers and registered organizations. Certified caregivers are individuals designated by a certified patient to assist them. And later in the presentation, we'll describe the term certified patient and registered practitioner. And there are specific rules pertaining to certified caregivers, but generally speaking, certified caregivers receive authorization from the State Health Department to obtain and possess medical marijuana through the program on behalf of particular certified patients. And registered organizations are those entities that have been approved by the State Health Department to manufacture and dispense medical marijuana under the program. For purposes of this portion of the presentation, we will focus on registered practitioners and the requirements related to them certifying patients. To be eligible, a patient must have what's called a serious condition, and that involves two components. The first component of which is one of the following debilitating or life-threatening conditions. So you see the list, cancer, positive status for HIV or AIDS, ALS, and so forth. There are 11 items going down to severe debilitating pain. So this represents the current list. The State Health Commissioner, by statute, has the authority to add additional conditions by regulation. You also have to keep your eyes out for changes from a legislative standpoint. For example, recently, and you might have seen in the news that there's a bill that's been circulating in the legislature with regard to the possible addition of post-traumatic stress disorder to the list, but that hasn't been added yet. To qualify as having a serious condition, a patient must also have one of the following clinically associated conditions, symptoms, or complications. And they're from a list. You'll see, for example, wasting syndrome, severe or chronic pain, severe nausea, seizures, severe or persistent muscle spasms. So a patient would have to have one of the conditions listed on the prior slide, one of the 11, combined with one of these symptoms or complications. Similar to the list of 11 on the prior slide, additional conditions or symptoms can be added by the Commissioner of Health. And generally speaking, and not including some of the additional requirements that we'll cover later, if the practitioner determines that a serious condition exists and that practitioner is registered with the State Health Department's medical marijuana program, and we'll get into that in a moment, the practitioner may issue the patient a certification, and we'll describe that, a certification allowing for medical marijuana. If the practitioner is not registered with the program, he or she could certainly refer the patient to a practitioner who is. So what types of practitioners can be registered with the state's medical marijuana program? They include physicians, nurse practitioners, and physician assistants who are under the supervision of a physician who is also registered under the state's medical marijuana program. And in order to register with the state's program, the practitioners have to meet certain requirements. Number one, they have to be qualified to treat one or more of the serious conditions that the patient must have, so one or more of the 11 conditions from the prior slide. This is from a scope of practice perspective. Number two, they have to be licensed in their profession in New York State and in good standing. Three, they have to have completed a 4-hour course on medical marijuana, and that's a course that's been approved by the New York State Health Commissioner. And finally, they have to be granted a registration by the State Health Department. And practitioners who satisfy these requirements are referred to as registered practitioners. So when can a registered practitioner certify a patient for participation in the medical marijuana program? Before I indicated that there are some additional specifics regarding when that can occur. Here they are. We'll get to more specifics later. But in general terms, a practitioner who's registered with the program can certify a patient if the following circumstances are met. Number one, if the patient has a serious condition, as we've discussed, and Sandy will get into this a little bit more later, but that serious condition has to be specified in the patient's medical record. Number two, the practitioner has to be qualified by training or experience to treat that medical condition. So it obviously has to be, within the types of conditions that the practitioner treats. Number three, the patient has to be under the practitioner's continuing care for the serious condition, and we'll get into that more in a little bit. And fourth, it has to be a scenario where, in the practitioner's professional opinion and review of past treatments, the patient is likely to receive therapeutic or palliative benefit from the medical use of marijuana for the serious condition. So we've talked about a practitioner issuing a certification to a patient, and we've also talked about the conditions under which a patient can be certified. So what's included in the certification? Here are some of the things, and as you would imagine, the certification is going to mirror the prior requirements that we discussed. So among other things, a certification has to include a statement from the practitioner that he or she is caring for the patient in relation to the patient's serious condition. And by statute, caring for is defined as treating a patient in the course of which the practitioner has completed, number one, a full assessment of the patient's medical history, and also an assessment of the patient's current medical condition. In addition, the certification would include the patient's diagnosis that qualifies him or her for medical marijuana, and also a statement that the practitioner is in fact qualified by training or experience to treat that serious condition. And in addition, for purposes of this slide, the certification also must include a statement that the practitioner's professional opinion and review of past treatments, the patient is likely to receive therapeutic or palliative benefit from the treatment of the serious condition with medical marijuana. And so what's important to note is that the certification must be signed and dated by the practitioner. So this is a matter of accountability in terms of ensuring that practitioners appropriately certify patients. Another one of the requirements is that a practitioner must review the patient's controlled substance history on the Prescription Drug Monitoring Program Registry before issuing a certification. So for those practitioners who are listening, this is the same thing that must be done when issuing a prescription for a controlled substance in another context. So again, this is part of the due diligence in terms of ensuring appropriateness from a clinical standpoint. So practitioners have to make some additional professional considerations when certifying patients. So the certification is required to state the date on which it will expire. So by law, that date can't be any longer than 1 year from the date the certification is issued. So that's the longest. It can be shorter. So a practitioner can include a shorter period of time on the certification. And there's one exception for the 1 year limitation, and that relates to patients who are terminally ill their certifications expire upon their death or upon revocation by the practitioner. Some other professional considerations for the practitioner that they must consider and that would be included on a certification would be things such as perhaps the brand of marijuana or the form, the administration method, the dosage, and any limitation in the use of the approved medical marijuana product. And in terms of dispensing, the amount dispensed at any one time cannot exceed a 30-day supply. And the dispensing would be done by the registered organization, not by the physician. So how does it work? How does the program work after a physician certifies a patient? So patients who are certified by registered practitioners, they then have to register with the state's medical marijuana program through the Department of Health's online patient registration system. After the registration is processed, the certified patient will receive a registry identification card that would entitle him or her to obtain medical marijuana from a registered organization's dispensing facility. And previously we've talked about designated caregivers. Patients who are registered with the medical marijuana program may designate up to 2 designated caregivers who are also issued registry identification cards after applying for them with the state health department. So when a patient goes to obtain medical marijuana from a dispensing facility, they have to bring their registry ID card, and they also have to bring the certification from their physician. And in those cases where a designated caregiver is going to obtain the medical marijuana for the patient, the designated caregiver would have to bring the registry ID card that the state health department issued to them and the patient's certification that was issued by the physician. There are a number of specific requirements that practitioners must be aware of to comply with the law. We're going to provide you some examples. Here are some on this slide. Before, we talked about the various debilitating or life-threatening conditions that can qualify as part of a serious condition. And some of those conditions have additional requirements. So for example, if a certification is based on a positive status for HIV or AIDS, the practitioner must obtain patient consent for disclosure of that pursuant to this process. So under the New York's public health law, there are specific provisions regarding disclosure of HIV or AIDS, and that's because of the heightened sense of confidentiality due to the nature of those conditions. Secondly, another example, if certification is based on severe debilitating pain, and that's a condition that was recently added by the commissioner to the list of conditions, certain things have to be satisfied. Number one, the practitioner must determine that the pain degrades health and functional capacity, or capability. And number two, the patient must have contraindications, have experienced intolerable side effects, or experienced failure of one or more previously tried therapeutic options. And in addition, there must be documented medical evidence that the pain has been lasting for 3 or more months since onset, or the practitioner reasonably anticipates that the pain will last for that period of time. So some additional specific requirements to be aware of, and Sandy will touch upon this some more. As we've mentioned, the patient's serious medical condition must be specified in their medical record. The medical record must also document that the practitioner has explained to the patient the potential risks and benefits of the use of medical marijuana. And the regulations have special rules for circumstances where a certified patient is a minor. And for example, in this circumstance, with regard to documenting this component, the practitioner must explain the risks and benefits to the patient's parent or legal guardian. and then make a determination if it's appropriate to explain them to the minor as well, and document those circumstances and those discussions in the patient's medical record. So the third item from this slide, the practitioner is also required to date and place his or her handwritten signature on the printed certification, as we've discussed, and provide that original to the patient. And the practitioner has to maintain a copy of the signed certification in the patient's medical record. The New York State law, it's highly regulated, and so there are additional requirements, including certain instances where practitioners are required to make certain reports to the state health department. That includes circumstances such as the death of a certified patient. In addition, if there's a change in status of a serious condition of a certified patient for whom the practitioner issued a certification, there has to be a report to DOH if it's a circumstance where that change may affect the patient's continued eligibility for certification. In addition, practitioners also have to report patient adverse events to the state health department. So any of this reporting obviously has to be done on a timely basis. Under the law, reporting must be done within 5 business days after the practitioner becomes aware of the fact, except in serious adverse events, they have to be reported not more than 1 business day after the practitioner becomes aware of it. In terms of having a system that's appropriate and safe, there are also specific prohibitions that practitioners have to be aware of, things that they cannot do. For example, a practitioner cannot directly or indirectly receive or solicit any item of value from a registered organization. Likewise, a practitioner can't offer a discount or anything of value to a certified patient based on a patient's decision to use a particular registered organization or a particular brand of medical marijuana. Also, when practitioners are examining patients for purposes of determining whether they have a serious condition and whether or not they can be certified for purposes of medical marijuana under the state's program, those examinations cannot occur in any location that's owned or operated by a registered organization. And similarly, they can't occur where any medical marijuana products are being manufactured or sold. And in terms of compensation, other than charging an appropriate fee for a patient visit, a practitioner cannot in any way, directly or indirectly, benefit from a patient obtaining a certification. So finally, some other examples of specific requirements to be aware of. Practitioners who participate in the system, so practitioners who issue certifications, they, along with their coworkers, their employees, their spouses, their parents, their children, their siblings, shall not have any direct or indirect financial interest in any registered organization. And that includes any formal or informal agreement whereby a registered organization would propose to provide compensation if the practitioner issues a certification or steers a patient to a specific dispensing facility. Things like that are prohibited. Likewise, practitioners can't issue certifications to themselves. They also can't issue them to their family members or to their employees or coworkers. So to the extent practitioners or any of those other people thought it might be appropriate for them to receive medical marijuana based on their conditions, they're going to have to go to a different practitioner for purposes of consideration of the issuance of a certification. Practitioners shall not receive or provide product samples containing marijuana. And also, we've talked a little bit about designated caregivers. A practitioner can't act as a designated caregiver for any patient who they have certified. So I've covered some of the specific requirements applicable to practitioners. Now, Sandy will discuss how to avoid violations of those provisions and others, as well as provide information relevant to hospitals, nursing homes, and other healthcare providers.
Thanks, Jim. So this may all seem overwhelming to those online considering participating in the program. However, having strong policies and procedures in place to make sure that all the requirements in law are met can help avoid practitioner pitfalls. For example, as Jim mentioned, it's likely that a patient will be referred to a practitioner who is authorized to issue certifications if the patient's own treating provider is not registered with DOH. So in that case, your policies and procedures will include obtaining the prior relevant medical records for the new patients. As Jim mentioned, the practitioner must certify that based in part on review of past treatments, the patient will benefit from medical marijuana. So obtaining the prior relevant medical records will at least show that there was a review of the past treatments and that was considered when certifying the patient. And also your procedures should include reviewing the Prescription Drug Monitoring Program registry. The law requires that a practitioner or his or her designee must check the registry prior to making or issuing a certification for the purpose of reviewing a patient's controlled substance history. And to the extent that you can show that your policies and procedures include all steps required in the law, you'll show that your conduct met the requirements of the Compassionate Care Act when you were issuing the patient certification. Another way to avoid pitfalls is to maintain thorough records. As Jim spoke on, there's numerous record-keeping requirements. And to document that all requirements of law are met, you should maintain appropriate records, including how the patient meets eligibility for the patient certification. You specifically must document that the patient or the patient's parent or legal guardian was informed of the risks and benefits of using medical marijuana. Now, in the age of electronic health records, in this case, the law specifically requires that you maintain a dated and handwritten signature on a printed copy of the certification in the patient's medical record. So, nowadays there's signature stamps and everything is done electronically, but you actually have to print off a copy of the certification, hand it to the patient, and then also keep a copy of what you gave to the patient in the patient's medical record. Again, as Jim mentioned, there are practitioner prohibitions that you should make sure you're aware of and comply with. Another way to avoid pitfalls is to avoid conflicts that are specifically prohibited in the law. Now, it may seem like a good idea for many different reasons to partner with a registered organization. And as Jim mentioned, there are various prohibitions against them, including that you can't receive anything of value from a registered organization. You can't in any way accept anything from a registered organization which seems to appear that you're steering patients to one registered organization over another. So when you're considering a relationship with a registered organization, just go back to the regulations, review the prohibitions, and see whether that conduct would run afoul of one of the prohibitions. In addition, other conflicts to avoid include not issuing a certification for yourself or your family member. You cannot be a designated caregiver to a patient to whom you issued a certification. You can be a designated caregiver to somebody else unrelated, but not to a patient that you issued a certification. Now, other things you should consider. The Compassionate Care Act provides immunity from liability, even against disciplinary actions or actions against the practitioner's license, as long as the practitioner's conduct complies with the law. So this is where your documentation, record keeping, and policies can assist. If there is a question as to whether a patient's certification was appropriate, your records will help show your compliance with the law, will help document how you determined eligibility, that the patient was eligible, and that all requirements have been met. The penal law creates the penal law has a crime for criminal diversion of medical marijuana. If a practitioner issues a certification with knowledge of reasonable grounds to know that the recipient has no medical need for it, or it is for a purpose other than to treat a serious condition as defined in the law. Again, this is where your documentation will help you. It'll show that you did the necessary check of the patient's eligibility, confirmed the eligibility, and issued a patient certification with reasonable grounds to believe that the patient would benefit from it. So can you get paid for office visits where a patient certification is issued? The regulations prohibit a practitioner from benefiting from a patient obtaining a written certification, but clarifies that the practitioner can charge an appropriate fee for the patient visit. So what would be an appropriate fee? You would look to how much you would ordinarily charge for an office visit, and if you're intending on charging more than your customary rate, is there a basis for it? Is there a reasonable basis for the increase in the charge that you would ordinarily bill a patient? The Compassionate Care Act specifically provides that an insurer is not required to cover medical marijuana. The Department of Financial Services issued a circular letter in 2017 clarifying this provision. And it basically said, if office visits are covered under the insurance policy or contract, and the insured receives services during an office visit that is normally covered, then the insurer cannot deny coverage solely on the basis that the patient received a medical marijuana patient certification. So that was what was like a two-pronged test. The office visit is ordinarily covered. The insured was there for services that would ordinarily be covered under an office visit. And as it just so happens that as a result, a patient certification was issued. The insurer wouldn't be able to deny coverage for that office visit solely on the basis that the patient certification was issued. However, coverage is not required for office visits that are solely used to obtain a patient certification. So you would look for the purpose of the visit and what was provided during the visit and what's covered under the policy. Now we'll focus for a little bit on hospitals. Can a hospital allow a patient to bring in and use medical marijuana in the hospital? The Department of Health issued new regulations that just took effect on May 17th of this year that help guide hospitals through the process of letting patients bring in and self-administer medical marijuana. Now, in order to authorize a patient to bring in and self-administer medical marijuana, the hospital needs to develop policies and procedures. And the regulations provide that the policies and procedures have to include verification that the patient has a patient registration card. So you take a look at the registration card. Is it valid? Has it expired? You'll want to make sure it's still current. If the patient has a designated caregiver, you'll want to verify that the designated caregiver's registration card is also valid. So the policies and procedures also have to include assessing whether the patient can self-administer the medical marijuana. This should include an assessment of the patient by an appropriate healthcare practitioner. As to who is an appropriate healthcare practitioner, the Department of Health clarified that the policies and procedures should specify which practitioners that the hospital determines may make this determination. And if the patient has a designated caregiver, is a designated caregiver able to administer the medical marijuana to the patient? The policies and procedures also have to include a determination of whether the patient or designated caregiver needs instruction on how to use the medical marijuana. So for example, if the route of administration is sublingual, does the patient know that he or she needs to put it under his or her tongue? Does the patient understand how to administer the medical marijuana? The policies and procedures also need to include a process where you actually see the medical marijuana and visually inspect it for integrity. Now, what does this mean? The law requires that medical marijuana be kept in its original packaging, which includes an appropriate label. And the Department of Health clarified that hospitals must develop policies and procedures to ensure that the approved medical marijuana product is actually in its original packaging and properly labeled. They further said that the hospital's policies and procedures should ensure that the quantity of medical marijuana in the package does not exceed the quantity indicated on the label, that the individual dose to be self-administered by the patient does not exceed the individual dose described on the label, and that approved medical marijuana products are not self-administered after the expiration date indicated on the label. So again, these are all requirements, as Jim mentioned, that should be directly on the label, and hospitals are required to take a look at the label and make sure that how the patient is taking the product, how much the patient is taking, all complies with what's on the label. The policies and procedures also must include a plan for securing the medical marijuana. You'll have to consider where will it be stored. Will it be stored in the patient's room in a safe, somewhere that can be kept secure from it being stolen? Are you going to keep it in a different location within the hospital? You must also document each time the patient takes the medical marijuana in the patient's medical record. Finally, the policies and procedures must include proper disposal of unused medical marijuana upon the patient's death. If the patient has a designated caregiver, the hospital could turn it over to the deceased patient's designated caregiver, or you could choose to turn it over to appropriate law enforcement for destruction or disposal. Now, for nursing homes and other healthcare facilities, currently there's no similar regulations for nursing homes or facilities. However, you should consider what policies and procedures the facility should implement if you're authorizing the possession and use of medical marijuana in the facility. And the hospital regulations can be instructive in this regard. Some things to consider. Does the resident need a designated caregiver if he or she doesn't have one? So how will the resident obtain the medical marijuana? Also, is the registered organization the resident usually obtains his or her medical marijuana from authorized to deliver medical marijuana? Can the resident self-administer, or does he or she need assistance? Other considerations: security, how to keep it safe. You'll have to consider this just as hospitals have to consider it. Where will it be stored? Will the resident have access to it if it's kept sole access, if it's kept in his or her room? How do you prevent against diversion? How will it be secured so that it's not stolen? Record keeping, how will the facility record that the resident is taking medical marijuana? There's also prohibitions on where medical marijuana may be consumed. So one approved form of medical marijuana is metered liquid or oil preparations for vaporization. and the regulations prohibit vaporization of medical marijuana products in a public place, including places of employment and in general hospitals and residential healthcare facilities, unless vaporization is done by patients in a separate enclosed room of the hospital or facility. The Compassionate Care Act makes possession of medical marijuana unlawful if it's consumed in a public place. So facilities should consider where they allow patients or residents to use medical marijuana. Now, this doesn't apply to vaporization. In a facility, that can only occur in a separate enclosed room. So with respect to the other products, the sublinguals or the capsules, usually you'd want this in a private area because it is unlawful if it's consumed in a public place. There's also employee issues to consider. So under the Compassionate Care Act, a certified patient is deemed as having a disability and cannot be discriminated against on that basis. That includes in housing, employment, and public accommodations. However, the law also provides that an employer can enforce policies that prohibit an employee from being impaired on the job. So while you can't discriminate on an employee because they are a certified patient, you wouldn't be able to use that as a basis to deny employment. You can still enforce your policies that prohibit employees from coming to work while impaired.
Okay, thanks, Sandy. So the medical marijuana program, one of the things that's important is to realize that in New York State, it's been a developing process, and also a growing program. The medical marijuana program continues to grow. As of June 14, 2017, there were almost 22,000 certified patients and almost 1,100 registered practitioners, and those numbers continue to grow daily. One of the reasons is since its inception, the program's inception, the State Health Department has taken steps to expand the program and provide qualifying patients even better accessibility in manners that are appropriate and safe. Some of the changes that the department has made since the inception of the program, one is originally only doctors could certify patients, but since that time the State Health Department revised its regulations to also add nurse practitioners and physician assistants. We had gone over previously the practitioners who could participate in the program, and we mentioned all three of those. Secondly, the State Health Department added, as I mentioned before, severe and debilitating pain to the list of debilitating or life-threatening conditions that can qualify as a serious condition. That list can change. It can change by regulation. The commissioner can add additional things, or again, things can be added pursuant to a legislative change. Third, the State Health Department has begun allowing registered organizations to deliver medical marijuana to certified patients' homes. So this obviously increases accessibility for patients who need it. Maybe it's a patient, for example, who doesn't have a caregiver or otherwise. The State Health Department also released a list of practitioners willing to make their status as registered practitioners public, thereby making it easier for patients to locate practitioners who can potentially certify them. So, for example, if you go on the State Health Department's website, you can see a list of those practitioners as well as information on where they're located. You've probably seen in news reports, the State Health Department has also issued some conditional registrations to 5 additional registered organizations and anticipates that those new entities will begin selling product in early 2018. So, as a matter, as you can imagine, if there are additional dispensing facilities through new registered organizations, that provides additional locations where patients can obtain medical marijuana. And also, as Sandy had mentioned, in May 2017, the State Health Department enacted regulations authorizing hospitals to enact policies and procedures allowing certified patients to bring medical marijuana in the hospital for self-administration. The State Health Department has also signaled that it may make additional changes. The first bullet references exploring ways to make it easier for healthcare facilities and schools to allow for the use of medical marijuana at those locations. This has already happened in some regard with regard to hospitals through the regulations. It looks like other possibilities may exist. In addition, the State Health Department has signaled that they may make general amendments to the regulations for the program to enhance it, including but not limited to streamlining manufacturing requirements and broadening the capabilities of registered organizations to advertise their participation in the program. So right now there are certain regulations with regard to registered organizations' ability to advertise. It looks like there may be some thought to revise those. So these items are included in the State Health Department's report titled Medical Use of Marijuana under the Compassionate Care Act 2-year report. Pursuant to the Compassionate Care Act, the Health Department's required to issue a report every 2 years to the governor and the legislature with regard to the status of the program and also suggesting potential changes to the program. The takeaway of this and the takeaway of what DOH has signaled and all the changes that we've mentioned is that the program is expanding and growing, and it will continue to do so. So that makes knowledge regarding the program and staying up to date on any changes as they occur all the more important. So for those who are listening, what do you do next? If you are a practitioner who is not registered with the New York State Medical Marijuana Program and you'd like to learn more, there's a lot of information on the State Health Department's website, www.health.ny.gov. Also, another option is we had previously mentioned that there's an online course that's approved by DOH. That's a course that a practitioner would have to take in order to become registered. If there was increased interest, increased curiosity on the part of someone who wasn't registered, they could certainly take the course. It has the benefit of providing 4.5 hours of a continuing medical education, so there's a benefit to it in that regard as well. And the course provides additional information. It covers the topics of the pharmacology of marijuana, contraindications, side effects, adverse reactions, overdose prevention, drug interactions, dosing, routes of administration, risks and benefits, warnings and precautions, and also the topic of abuse and dependence. So what do you do if you're a practitioner who is registered with the state's program, or if you're another type of healthcare provider, such as a hospital or a nursing home? So reinforcing some of the things that Sandy mentioned, one thing that's critical is if you don't have policies already, you want to develop policies. You want to make sure that you have policies to ensure compliance, and policies are also, a great centralized way to look at all the requirements and make sure that you have processes and procedures in place to ensure compliance. If you already have policies, then you'll want to review them to make sure they're up to date, maybe review them to make sure they're sufficient, not only with regard to the original regulations under the program, but with regard to changes that have happened. Also tying into some of the things that Sandy had mentioned, you want to stay informed about the federal policies regarding medical marijuana, and of course, as we've been talking about throughout, stay up to date on the Department of Health regulatory changes and program developments because they're certainly important. So if you have any questions, by all means, feel free to contact either Sandy or myself. Our email addresses are listed on this slide, as well as our telephone number here in the Albany office. I also want to stress that this presentation only covered a limited portion of the types of issues or questions that can arise in the context of medical marijuana. With Garfunkel Wild's nearly 100 attorneys in its 4 offices, it certainly has experience to handle almost any issue that can arise, whether it relates directly to the medical marijuana program, employment issues related to medical marijuana, as Sandy had mentioned, financial or banking transactions involving participants in the medical marijuana program, like registered organizations, corporate matters, general practice issues, hospital issues, nursing homes, etc. We have the folks here who can help you, so please don't hesitate to contact us. So we reserved a little bit of time for questions and answers. It looks like we only have about 4 minutes or so left, so we can see if we can go through a couple of questions. Sandy and I can go back and forth, but here's a question. You stated that physician assistants must be under the supervision of a physician registered under the medical marijuana program, as well as being registered themselves. The nurse practitioners also have to be under the supervision of a physician who's registered in the program. So the answer to that is no. The regulations do not require that for nurse practitioners. Nurse practitioners work collaboratively with physicians, but under the New York education law, they aren't required to practice under the supervision of a physician, unlike physician assistants who are required to do so by the education law. So requiring a physician assistant's supervising physician to register under the medical marijuana program ensures that that physician assistant is practicing within the scope of practice of the supervising physician. Sandy, do you want to handle a question?
Sure. This looks like one from a hospital. If the patient brings medical marijuana product that isn't in its container, for example, pills in a pill box, can the hospital still allow the patient to self-administer it while in the hospital? The answer to that is no. The Compassionate Care Act requires that the medical marijuana be kept in its original packaging, and the DOH regs require the hospital to include in the policies and procedures that it visually inspected the product and confirmed the visual integrity of it. And the Department of Health clarified that this meant observing that it was in its original packaging with the appropriate label. So if the patient brings product in outside of its original packaging, that in of itself would be inconsistent with the Compassionate Care Act, and the hospital wouldn't be able to meet its requirement under regulations as well.
Great. So it looks like we're getting close to the end of the presentation. If you, again, if you want to contact us with any questions, please feel free to do so. If you want to learn more about us, our bios are at the end of the presentation. So we thank you for taking your time to listen to the presentation, and we hope that you have a great day. Take care.